Thank you, Mr. Speaker. The last time the Government of Canada ordered Canada Post employees back to work, the courts ruled that legislation to be unconstitutional. One of the ways we normally try to make sure that legislation is constitutional is by having a full debate on it in this House and also by having a full study of it at committee. So I'd like to ask the Minister why she is putting forward a motion to limit consideration of this potential legislation to only a couple of hours, and how is she so confident that it's going to be constitutional this time?
The Honourable Minister of Labour.
Thank you, Mr. Speaker. As I said before, I am putting forward a motion today, which does not necessarily mean we will be debating the legislation. I am hopeful that the parties will reach an agreement, and we encourage them to stay at the table and get that deal. Having said that, we know that Canadians are expecting us to act quickly. As I mentioned in my speech, Canadians are struggling, whether it's individuals who are waiting for payments of a variety of different kinds, whether it's small businesses that are on the cusp of potentially going out of business, whether it's other businesses that rely on this time of year for their most profitable time. And so we will take action as the Government of Canada to ensure that all Canadians' needs are met. Thank you, Mr. Speaker.
Thank you, Mr. Speaker. Government members have been trying to justify back-to-work legislation by noting that management and the union did not avail themselves of arbitration. So I'm wondering if the member for Pitt Meadows Maple Ridge could clarify whether the government is contemplating back-to-work legislation that would require binding arbitration, or whether the government is contemplating back-to-work legislation that would impose a settlement designed by the government itself.
Member for Pitt Meadows, Maple Ridge.
Thank you to my colleague from the other side. Look, as a government, I think that we have shown that we're not taking heavy-handed approaches to solving problems. We've given latitude to both organizations to help them find a way. We stepped in. We've given them arbitration. We've given them special mediators. Every step of the way, we have tried to help them pass the impasse that they're at right now. What we are doing today is preparing that if they cannot do it, we do have to find a way to move forward. And what that picture will look like, well, we'll see what happens after this. Thank you.
Thank you, Mr. Speaker. The member for Jonquière and I both worked on the Government Operations Committee study on the future of Canada Post, which I think quite clearly showed that cutbacks and concessions are not the way forward for Canada Post. Today we have the government introducing a motion to try to sharply limit the amount of time to debate and consider back-to-work legislation for Canada Post employees. This is particularly concerning in light of the fact that in 2016 the Ontario Superior Court ruled that the 2011 Conservative back-to-work legislation had been unconstitutional. So I would ask the member for Jonquière whether she believes that the Liberal back-to-work legislation is any more likely to be considered constitutional, or whether it would be yet another unconstitutional violation of fundamental workers' rights. Thank you.
The Honourable Member for Jonquière. Thank you, Mr. Speaker. And I'd like to thank my colleague for the question. It's true that we have worked well together in committee on Canada Post. Several studies have been undertaken, even though the report really wasn't taken into consideration, and several points in that report were simply forgotten on the part of the government. It was probably voluntary, but anyway, we worked well together. That is true. But let's come back to the question now. I'm not a judge. I'm not an arbitrator. I can't necessarily make a statement on what will be constitutional and what won't be. However, I did speak about the right to strike. The right to strike is a constitutional right. And the 2011 Conservative bill led to rulings, and the rulings were on what was constitutional and what wasn't. And it turned out that it was an unconstitutional bill. Now, at the time, The issues were about unpaid leave and paid leave and sick leave. Many people had had operations and had not been paid. Now, if once again we go to the courts, well, what will happen? Well, we'll have to wait for 2 or 3 years, just like in 2011, and that's what I'm concerned about. You know, right now what we're talking about is safety. That's the major concern and issue for the workers. You can't get safety increased simply in 2 or 3 years. Action has to be taken now, and you get to those measures through collective bargaining and through negotiating. That's how solutions are found. And who is in a better position than the workers to know what the reality is on the ground and what the needs are? So we don't need a special bill in this House to simply impose the government's will and put pressure on the workers on the pretext that nobody will get their mail. That's simply false. Delivery is happening on time, and that's important. Under this bill, their right to free and collective bargaining is being trampled on, and the right to strike is a constitutional right. Questions and comments?